Today I want to briefly discuss a few of the issues that need to be considered in divorces when one or both of the parties are in the military. First, you need to know the 10-10-10 rule for retirement. This means that 10 years of active duty service have overlapped 10 years of the marriage. If this rule isn't satisfied, it doesn't mean the spouse isn't entitled to a pro rata share of the retirement, but it does mean that DFAS, the Defense Finance and Accounting Service, will not pay the retirement directly to the other spouse. So you need to decide if you're going to trade off the retirement for another benefit, how that's going to be handled for tax consequences, and you may want to consider whether or not to trade off that potential asset for some other benefit. You also need to know the 20-20-20 rule for TRICARE. If 20 years of the marriage overlaps 20 years of service, then your spouse can remain on TRICARE after the marriage ends. They will enroll in a DEERS program, they'll get their own number, and this will be an ongoing benefit for them. If the marriage is 20 years or longer, and there's 20 years or more of military service, but only 15 years of the two overlap, then your spouse can remain on TRICARE, but only for a year. Third, when we're talking about child support, you need to know how to read an LES. The child support is not calculated off of just the base pay. You need to consider the housing allowance, BAH, the food allowance, BAS, and any other special pay that the military member is receiving. Since all of these are cash benefits, they need to be factored in when running the child support guidelines. Finally, if the military member is no longer in the military and receiving VA benefits, since May of 2012, in a case called Brownell versus Brownell, the New Hampshire Supreme Court has said that these benefits can be factored in when looking at alimony and child support. You should read the case, make sure you have an attorney who's familiar with the case and able to apply your military benefits or the military benefits of your spouse to determine how that might be applicable in your case. The foregoing is not an exhaustive list. In a divorce where one or both of the parties are in the military, make sure you have an attorney involved that is experienced in military divorces.
At Manning and Zimmerman, we are committed to fighting for the rights of our client. When it comes to family law matters, an attorney can advise and assist you through a difficult time in your life. Shouldn't you have an experienced attorney working for you? Please visit our website at manningzimmermanlaw.com or feel free to call us at 603-624-7200.